Welcome to this explainer on constitutional amendments, where we're going to get right into the details of the ultimate legal battle. We're looking at a huge question today. Who really holds supreme power in a democracy? Is it the written constitution itself, the parliament that writes the laws, or the courts that interpret them? It is a totally fascinating tug of war, and we are going to break down exactly how this power struggle has played out at the absolute highest levels so that all these concepts are clearly understood.
All right, here's our roadmap for today. We'll start with the power to amend, look at the mechanics of addition, variation, and repeal, walk through the actual amendment procedure, and then dive into two massive legal showdowns, Sankari Prasad and Sajjan Singh.
Starting off with Section 1, the power to amend, specifically Article 368.
Right, so Article 368 is basically the master rulebook. It's the specific provision that gives Parliament its constituent power to literally change the Constitution itself. Think of it like editing a massive symphony. You've got this beautiful, complex musical score, right? But to keep it relevant for a modern audience, sometimes you need to add notes, change the tempo, or maybe even cut entire stanzas. The Constitution isn't just a dusty old document. It's a living, breathing thing that has to adapt.
Moving right along to Section 2, addition, variation, and repeal, the actual mechanics of change.
So Article 368 gives Parliament three very distinct ways to edit the rules. First up is addition. This is exactly what it sounds like, expanding the Constitution with totally new elements. It's like writing a brand new chapter into the rulebook to handle stuff the original framers just couldn't have predicted back in the day.
Then we have variation. Now, this isn't about throwing things out entirely. Instead, it's about tweaking or modifying the scope of existing rules. Just adjusting the phrasing or modernizing a law so it actually works better for society today. And finally, repeal. This is the eraser. If a provision is totally outdated and just doesn't serve the nation anymore, Parliament can completely delete it so it has zero effect moving forward. Okay, Section 3, the amendment procedure. Let's look at the specific steps to alteration.
How does this actually happen on the ground? You definitely can't just cross out a constitutional law with a red pen. There's a really strict three-step hurdle laid out. First, you have to introduce a bill in either House of Parliament. Step 2 is the tough one. The bill needs a majority of the total membership plus a 2/3 majority of members present and voting. So, yeah, you need overwhelming consensus for this. Once it finally clears Parliament, Step 3 is getting the president's assent. Give it the green light, and boom, the Constitution is officially amended.
But wait, there is a huge catch here. If you're trying to mess with core federal structures, like the election of the president, powers of a high courts, or the distribution of powers in the 7th schedule, Parliament can't just do it alone. Even altering Article 368 itself requires an extra hurdle. You actually need at least half of the state legislatures to ratify the amendment before it even goes to the president. It's a massive safeguard designed to stop the central government from just unilaterally grabbing power from the states.
Which brings us to Section 4, Sankari Prasad, the first real test back in 1951.
Let's pivot from the dry rules to the actual battlefield. This timeline shows just how fast things heated up. The Constitution commenced in 1950, right? Almost immediately, the government tried pushing land reforms, but the high courts kept striking them down. So, in 1951, Parliament fired back with the First Amendment, adding Articles 31A and 31B to protect their laws. That move triggered the Sankari Prasad challenge, and this tension would just keep simmering until it absolutely exploded in 1965 with the Sajjan Singh case. In the Sankari Prasad case, the petitioners came swinging with a genuinely brilliant argument. They pointed straight at Article 13, Clause 2, which says the state cannot make any law that takes away your fundamental rights. They argued, hey, a constitutional amendment is technically a law, right? So Parliament can't use an amendment to strip away our fundamental rights. It was a massive, direct collision between Article 13's protections and Article 368's power to amend. So what did the Supreme Court do with this giant contradiction? Well, they used a legal trick called harmonious construction. They basically said, look, the word law in Article 13, that only means ordinary legislation, the everyday rules of government. It doesn't apply to constitutional amendments made under Article 368's constituent power. Bottom line, they ruled Parliament's amending power is absolute and literally cannot be blocked by fundamental rights. And that takes us to Section 5, Sajjan Singh, the second major test in 1965. That first ruling gave Parliament a huge green light. But as the years rolled on, the amendments just kept piling up, constantly pushing the limits.
Fast forward to the Sogenson case. The petitioners here were trying to strike down the 17th Amendment, where Parliament had just dumped 44 new acts into the Ninth Schedule, which is basically a constitutional vault that shields laws from judicial review. The petitioners claimed this indirectly messed with high court powers, so it should have required state ratification. They also argued Parliament had no business touching land laws at all. But their biggest demand? They wanted the court to completely rethink its stance from Sankara Prasad.
Now, this case was a total watershed moment because it literally split the court. You had a 3-judge majority who stuck to the old rule, saying Parliament's amending power is incredibly wide, and yes, it totally includes the power to take away fundamental rights. But, and this is absolutely crucial, a 2-judge minority fiercely pushed back. They planted the seeds for what would soon become a constitutional revolution.
These dissenting judges were genuinely worried. Justice Mudholker raised a foundational question. He basically asked, if you strip away basic rights like equality and liberty, are you really just amending things? Or are you actually rewriting the Constitution and replacing it with something completely new? He strongly believed fundamental rights aren't just temporary legislative gifts that a passing majority in Parliament can easily yank away.
Justice Hidayatullah backed him up and drew a really hard line. He declared, quite famously, that Parliament is a constituted body, meaning it was created by the Constitution. It is not the original constituent assembly. Because of that, Parliament owes its allegiance to the Constitution. It doesn't get to stand above it and just tear fundamental rights apart.